Okay. Good morning out there. I hope everyone's having a great day and a great week so far. I am Sarah Higgins. I'm the Member Education and Events Director with the New York State Restaurant Association. And today we are joined by our good partners at Jackson Lewis, Adam Gross and Catalina Cadavid. And they are going to do, we'll say, a greatest hits collection of reminders and refreshers for compliance for hospitality employer regulations. As a reminder, we're recording the presentation and it is available to NYSRA members to view at any time in our webinar archive. If you have any questions about how to access the webinar archive, you can email us at info@nysra.org. If you have questions for Adam and Catalina as we go along, we're going to take those at the end, but you can always enter those into the Q&A box, and we will get to those at the end of the presentation. As always, this is not legal advice. It's information for you provided by Adam and Catalina, and I will turn it over to them to get started. Guys, thanks so much for joining us, as always.
Thank you, Sarah. Good morning, everyone. It's good to be back with this group. It's been a while for me personally. We wanted to, Sarah had the idea that it would be a good idea as we turn to the page from 2023 to 2024 to just do a bit of a refresher on some of the biggest landmines that are out there compliance-wise for restaurants. So that we can make sure everyone is thinking about the right things, that we can make sure that everyone's dotted their I's and crossed their T's, and hopefully can avoid the technical violations that sometimes lead to very punitive penalties. So we've picked some topics that we are, that are, oldies but goodies, so to speak. But if people have questions about other things that we did not cover from a general compliance perspective, feel free to add those questions into the Q&A as well, and we can try to get to, we'll leave some time at the end and try to get to them. So with that, we are, Catalina, you can go to the next slide, please, if you don't mind. So Catalina and I both work for Jackson Lewis. Jackson Lewis is an exclusively workplace law firm. So we represent employers like those of you on the line in the hospitality industry, but also any other industry around the country with offices across the country. And we are a partner with businesses exclusively. We only represent businesses, and we represent businesses only in connection with issues that they have with their employees. And Catalina, you can keep moving. Yeah. So we are focused entirely on the workplace. So the idea is that wherever you might have employees or you may have operations, we have boots on the ground, so to speak, and we can assist in any sort of workplace issue, whether it be immigration, whether it be benefits, whether it be litigation, whether it be restrictive covenants, whatever the area is, we have practice groups, so long as it deals with the workplace, that is right in our wheelhouse. So with that, why don't we get started on our topics for today? And we started with just some recent updates this year. So it had been a number of years, at least in certain parts of New York State, since there had been a change to the minimum wage. And with the change to the minimum wage and to the tip credit, which we'll address on a slide in a moment, there are changes that flow from that. So as a just general basic overview, we wanted to make sure that everyone was aware, hopefully everyone is aware of the fact that as of January 1st of this year, the state minimum wage increased. In New York City, Long Island, and Westchester, it went up to $16 an hour from $15 an hour. Elsewhere around the state, it's at $15 an hour. That is new as of January 1 of this year. And we will talk about in a few minutes the changes that flow from that.
So these are the updates to the general minimum wage, but as you know, this also changes the tip credit. So with the new $16 minimum wage, that means that food service workers must receive a cash wage of at least $10.65 an hour. for all regular hours, and that means that restaurants can take a $5.35 per hour tip credit. Outside of the New York City and Westchester area, that'll be $10 an hour minimum and a $5 an hour tip credit for food service workers. And for other service employees and hospitality, that'll be $13.35 an hour minimum cash wages and a $2.65 tip credit. And outside of the New York City, Westchester area, it'll be $12.50 an hour cash wage and $2.50 tip credit.
And just a few reminders about that. Just number one, you can see from the slides that these rates are they're slated to increase again as of January 1 of 2025, and then again as of January 1 of 2026. So all of the requirements that we're going to talk about in the next few minutes that flow from these changes are going to be true again in 2025 and 2026. So you're going to have to do a lot. There's going to be additional paperwork required again for the next couple of years, no matter where you are operating. The other thing I just want to mention briefly, food service employees, I assume most of you know, but those are your front of house tipped staff. Service employees, you might be asking yourself, well, what are service employees? Service employees are tipped employees regularly working in tipped positions, but non-food service employees. So for example, delivery people might be one example, bathroom attendants, those are some examples of categories of worker who might fit into that category.
That's right. And there's also an increase to the New York State threshold for salaries for exempt employees. In 2024, that means exempt employees, your managers, will have to receive at least $1,200 a week or $62,400 per year. And outside of New York City and Westchester area, it'll be $1,124.20 per week, which is a very specific number, which goes to $458.40 per year.
And Catalina and I have found that this one is an area that, most people were clued into the increasing minimum wage, but that this one is an area that may have eluded some people, might have been off the radar a bit for people. This is just as a reminder, if you have exempt employees, which in your restaurants is mostly going to be your managers, right? Again, reminder that to be a manager and to be exempt from overtime, there's a two-pronged test. You have to meet the salary basis threshold. You have to pay a salary, a regular salary without deductions, except for very limited reasons, of at least the amount that Catalina just went over. If you do not meet that threshold, you could hire the best lawyer in New York State. There's no defense to that. You either pay above the threshold or you don't. So this is one of those areas where, everyone should be reviewing the salaries of the managers that they are employing and making sure that you're above the threshold.
That's right. So what do these increases mean for you for compliance? It means that it's going to affect the rate at which employees should be paid for spread of hours, which we're going to discuss in the next slide. And it also means that you need to give all your employees updated annual wage notices because of those rate changes. So as you know, spread of hours is when an employee's workday spans more than 10 hours. And that does not mean that they work more than 10 hours in a day for you. It means that the beginning of their day and the end of their day, whether there's a break because the business closes for when there's no service or because they take a break themselves, if it spans more than 10 hours, they need to receive this extra hour of pay at the minimum wage rate. So that's the whole minimum wage rate, the $16 this year, $16.50 next year, and not the tip credit rate.
Right. And so Catalina said it exactly how I would have done it. But just to emphasize, to repeat it, because this is one of the most common issues that are confused by those restaurant clients with whom we regularly work. It is not, spread of hours is not a measure of how many hours you are clocked in during the course of the day. You take the elapsed time, the spread, from the very first clock in to the very last clock out. So you could have someone working a spread, who's entitled to a spread of hours payment, who only worked 6 hours. But if they clocked in for the first time at 10:30 in the morning and clocked out for the last time at 9 o'clock at night, that is a 10.5-hour spread from first clock in to last clock out. They are entitled to 1 additional hour of pay at the full minimum wage, whatever that is, where you are. So in the New York City area, at $16 an hour, it could be $15 an hour elsewhere around the country, around the state.
Yeah, and
Denise,
before-
can I just hop in? I'm sorry.
Yeah.
Can you just the grouping, the geographic grouping across the state for the different wages? Can you just clarify? Because I think I just want to make sure people know that Long Island is also included in
yes.
the higher rate. Yeah. Okay.
Yes, sorry.
That's right. I'm sorry, I
It's really
left that out.
downstate and upstate. So the New York City area we're referring to really as Nassau County, Suffolk County, and Westchester. Outside of those areas, those are the areas that are grouped with New York City in terms of what those current wage rates are. Elsewhere,
Great.
it's a lower rate.
Okay. Thank you. That's all. I just want to make sure we're clear.
My New Jersey is showing. Sometimes I just lump Long Island with New York City. And before we move on, I just wanted to say, so Adam and I defend a lot of cases. We see a lot of stuff, and we also get to advise clients on the front end. We have that privilege and help them set up so that they can avoid some of the pitfalls that we see in litigation. And spread of hours is something that's usually thrown in because it's an easy mistake if you're not aware of it. So we advise, restaurant groups, we advise small restaurants, and we see that this gets added to almost every complaint, whether the plaintiff's lawyer knows that it happened or it didn't happen. It's just an easy throw in that, if litigated on a class basis, can make a lot of money for plaintiff's lawyers. So they always throw it in. It's something that is very important to be careful about.
And I think that's a great point, because one of the things that I'll just mention briefly is that in our experience, this is something that you have to be proactive about with your payroll company. So even though all of the payroll companies with which you work are familiar with spread of hours and know how to program to ensure that employees are paid for spread of hours, but they won't necessarily do that for you unless you proactively ask them to. So everyone should be making sure, like spot checking, to make sure that if there are issues of spreads, that the spread of hours is actually being paid, and if not, should proactively reach out to the payroll company that you are working with to make sure that that gets reprogrammed accordingly.
Yes, and this is the other claim that we see thrown into complaints all the time. So every employee needs to be given a notice of their pay rate before they start working for you, and every time that the rate of pay changes. So in this instance, it's going to be triggered by that January 1st a raise anytime that any employee gets a raise, or anytime that you're onboarding someone. And it is very important to keep a record that you have given this wage notice to your employees for 6 years. Adam and I see this claim all the time. Again, plaintiffs' lawyers will just put it in whether or not they think that there was an actual violation, because so many people either don't provide the notice or forget to keep a record of it.
Yeah, sorry, Kat, I didn't mean to cut you off.
No worries. Go ahead.
So I would say that this is if you were to take away one thing from, we would hope you take away more than one thing, but if you were going to take away one thing from today's webinar, the importance of the wage notice form, especially with respect to tipped employees, is paramount. It is the number one and I'm going to explain why. It is the number, we see this in every single litigation that involves a restaurant without fail, every single one. And the reason is because the penalty for failing to provide this one little piece of paper is so punitive, frankly, unfairly so, if you would ask Catalina or myself, and I'm sure that everyone on this webinar would agree with us. The penalty it's twofold. So if we take a tipped employee for whom you are taking a tip credit, so if you are in upstate somewhere and you're taking a $5 tip credit, or if you're in New York City and you're now taking the $5.35 tip credit, you're only allowed to take the tip credit by law if you satisfy certain requirements. One of those requirements is providing adequate notice to the employees that you're taking the tip credit, and verbal notice is not going to be sufficient. So you have to provide them a notice in writing that says we are taking the credit against the minimum wage. The way that that is typically done is through this wage notice form. So if you do not provide that wage notice form at any time, both at the time of hire and at any time when the tip credit amount changes, which it does this year, which it did this year, and it will the next couple of years, you are vulnerable to a claim that you should have provided this notice, you didn't, and because you didn't, your employees did not have adequate notice of the tip credit, and therefore every hour that they worked with inadequate notice and were paid at the tip credit rate should have been paid at the full minimum wage. So depending upon where you are in the state, that can be a $5 or $5.65 an hour per employee claim for whatever period of time that you did not provide the notice. And then if that's not bad enough, which, most of us would say is already entirely too punitive for a form when everybody knows that they're being paid a tip credit because it's very common within the industry. If that's not bad enough, in addition to failing to that penalty, if you fail to provide the wage notice form at the time of hire, and arguably, depending upon which court you look at, on an annual basis or when there are changes thereafter, you also are subject to an up to $5,000 penalty per employee who has not received a compliant form. So you are penalized in two distinct, very meaningful ways for failing to provide compliant and timely wage notice forms to employees. If you're, again, it is in every litigation. It's the root of of most of the liability in these cases. And so we can't really emphasize enough how important it is that you are on top of timely distributing these forms.
That's right. And these forms can be found on the New York Department of Labor website. They have basically a form for any type of pay arrangement. They have, commissions, tipped employees, multiple rates, salaried employees, and they have several translations. It's very important that you give this notice in the primary language that the employee identifies. So we have a couple samples. Adam, you were gonna.
Yeah, so this is from just from a screenshot from the state Department of Labor website. The forms are called, if you Google, Wage Theft Prevention Act forms. So that's the name of the statute that made this a requirement back in 2011. Wage Theft Prevention Act forms. You'll see all different examples of forms. This is just a regular, hourly rate employee. So just keep in mind, and we're happy to you should talk to your employment counsel, et cetera, because there are some other requirements under federal law that sometimes can be built into these notices that are not built into the state's model notice. And so that's something to just make sure you're on top of, whether in the notice or elsewhere, like in the handbook or somewhere else. But the basic idea is this, and this is another very, very common mistake. When you're filling out this form, the employee's rate of pay, if we're talking about a tipped food service employee, is typically going to be the full minimum wage. So regular rate of pay will be, $15 or $16 an hour. If you are taking a tip credit, or if you're taking a credit for meals, you will check the appropriate box in number 4 where it says allowance is taken. Either it'll be none, or if you're taking a tip allowance, you'll put in the amount of the tip credit. If you're taking a meal credit, you'll put in the amount of the meal credit. That is how you provide the notice of the tip credit. So importantly, the rate that you put in terms of the number 3, in terms of their pay rate, is not the tip credit rate. It's actually the full minimum wage. That's confusing. Frankly, I think it's confusing for employees, but that's the way that the Department of Labor has said it is supposed to be done. And that means that the overtime rate is therefore the time and a half, the minimum wage, the full minimum wage, not the tip credit overtime rate. So that is the way that these forms are filled out. As Catalina said, very importantly, there are all sorts of different languages. These forms are available in like 8 or 10 different languages. You have an obligation to provide this form to your employees in their primary language, unless there is no template of whatever the employee's primary language is on the Department of Labor website, and in that case, you can provide it in English. But if there's a Spanish-speaking employee, there's Mandarin, there's a whole bunch of languages on the Department of Labor website. If you have an employee who speaks one of those primary languages, they should get this form in that language. Now, that language also has English in it, so you can read it as well, but it has both English and whatever the language is.
And you don't have to provide this exact notice. Oh, sorry, Sarah, you were gonna.
I was gonna pop in and ask a question. And I don't know if you're gonna get to this, Catalina, so I apologize.
Mhm.
But what's the requirement for having the form signed or acknowledged of receipt to the employee? So you've given it to the employee. Are there
Yeah, so you'll see, that's a good question, Sarah. So you'll see on the right-hand side, so this form needs to be filled out completely and accurately. So all of this stuff that frankly, again, seems relatively meaningless, you will be, there are arguments out there that if it's not filled out entirely accurately and completely, so that includes like looking on the left-hand side in the employer information box, you have to include the mailing address, the physical address, the phone number of the employer, the correct corporate name, the doing business. If that is not all filled out correctly, including on the right-hand side to your question, Sarah, the employee's name and the employee's signature. So it is not enough to just give the employee this form. They actually need to sign the form. Now they can sign it electronically, that's okay. But there has to be some sort of signature from the employee. If there is not, it's not a complete and compliant form.
Okay, that was just a question and I thought it would be pertinent to answer. Okay.
Yeah.
So what I was going to say before is that it does not have to be this exact form that you provide the employee. The requirement under the statute is to provide this information, but we highly recommend using the forms on the Department of Labor website. They have done all the work for you. That avoids a lot of the headache, but you can also add things to them. So at Jackson Lewis, we work with our clients to make sure that they're buttoned up for any litigation that might come up. So we add usually language explaining the tip credit even further, so that there's no question. Like Adam said before, the penalties for this is not just the $5,000, but it could be the loss of that tip credit. So we make sure that there's additional language so that the employee is super covered and knows that a tip credit is being taken against their wages, and there's no doubt in anyone's mind that they were given notice of that. Okay, so in addition to the wage notice, employees are entitled to receive a pay stub, essentially, with certain information, and that information is the hours worked, the rates, the credits claimed, which includes tips, meals, lodging, and any other deductions that you're taking from their wages. I believe there's a sample pay stub on the Department of Labor website. You can just Google sample, like New York sample pay stub, and they have one with all the minimum requirements. And this mirrors that wage notice penalty if you do not provide a wage statement with every payment of wages. it's also a $5,000 penalty per employee that did not receive the wage statement.
And this is another example where you sometimes requires some proactivity with your payroll company, because technically you have to provide some sort of indication on the pay stub, on the wage statement, that if you are taking a tip credit for an employee, that information is included on the wage statement. And you know, if we're being candid, that is not always something that your wage statements are automatically programmed to do. And the model wage statement that exists on the Department of Labor website is not a model that is always able to be recreated by a payroll company. So it doesn't need to be in that same format, but you have to work with your payroll company to ensure that there is some notice to the employee, so that when they go and look at their wage statement for the week, they can see how many hours were they working at the tip credit rate versus the full minimum wage, for example, what the amount of the tip credit rate was. That information is crucial to include on the wage statement.
And then in addition to that, there's certain notices that need to be posted visibly at your restaurant, and a list of those notices can be found on the Department of Labor website, and it includes things like New York harassment law and employee rights. Yeah.
Sorry, it's me again. I'm just going to pop in with this question because we had a few people ask the same question right away. If you're, okay, can it be not only be with the hard check, but as long as the employee has the ability to log into their portal to see this information, is that
Correct.
okay? So if they're just getting a check, that's okay. But if they have access to this, that's fine.
Correct. I mean, a lot of employees don't get hard checks anymore, right? There's,
Right.
you know, direct deposit, et cetera. That's completely fine. The point is that there needs to be available or accessible to an employee on a weekly basis their wage statement, whether that is in hard copy form or through whatever portal, you know, the employer uses to make that information available.
Okay, thank you.
Okay, so moving on to the 80-20 rule, which is seemingly always a hot button issue. So people, we've gotten a lot of questions from restaurant clients over the last couple of years, because 80-20 has been in the news regularly, because there has been a lot of activity with regard to 80-20 on a federal level, meaning that the rule was abolished for a bit. There was a new proposed rule by the Department of Labor. That rule has been challenged in various courts around the country, and its status is still very much up in the air depending upon where you are. None of that activity is really relevant in New York, because New York has its own labor law, and it has its own hospitality regulations within that govern your industry. And within those regulations, there's a very clear codified rule on 80-20. So regardless of, so one of the sources of confusion that we've dealt with is, you know, employers thinking, well, we don't have to worry about 80-20, or we have to worry about 80-20, you know, with respect to this federal rule. Really, we're talking about in New York's rule, which is different than the federal rule. And the reason we're not as concerned, generally speaking, about the federal rule is because the federal minimum wage, believe it or not, is still $7.25 an hour. The New York minimum wage is either $15 or $16 an hour, depending on where you are, but the tip credit rate is at least $10 an hour. So you're always paying, even if you're taking a tip credit, you're always paying above the federal minimum wage, because the tip credit rate here in New York exceeds that $7.25 an hour. So what is New York's 80-20 rule in simple terms? New York's 80-20 rule determines not whether someone is eligible to receive tips necessarily, but whether you're eligible to take a tip credit for that employee on a day. And if an employee works more than 20% or 2 hours, whichever is less, of the workday in a non-tipped role, then you fail the 80-20 test so to speak, and that employee must be paid the full minimum wage for that entire day, not just for the hours in which they are performing the non-tipped work, the entire day. That is very clear under New York's rules. So a couple of examples here. So we have employee 1 works 3 hours before service doing inventory, so clearly non-tip generating work at a pay rate of $25 an hour, so well above the minimum wage, and then works a shift as then clocks in as a server for a shift and works typically at a tip credit rate. So can the employer take the tip credit for that shift? The answer is very clearly no, because even though the employee is eligible to receive tips for that shift because the employee worked in a tipped position for the full shift and would be eligible to receive tips or to participate in a pool, the 80-20 rule fails because the employee worked 3 hours during that day and also more than 20%, but you don't need both, just one, in a non-tipped role, and therefore they have to be paid the full minimum wage for the entire day. Example 2, server scheduled for a lunch shift, works from, the lunch is served from 11:30 to 3. The employee clocks in from 10:30 to 11:30 to do some pre-shift and setup, but it's before lunch is actually, there's no customers in the restaurant at that point, so it can't be directly tip producing work. Employees cut at 2:45, so they've set up for an hour. They do service work for 3 hours, 25 minutes. Is there a potential violation of the 80-20 rule? Yes, because 1 hour divided by the 4 hours and 25 minutes that the employee actually worked is more than 20%. I think it's like 23%. So you fail the 80-20 rule in that instance, and that employee would also need to be paid the full minimum wage for the entire day.
Okay, so let's move on to tip sharing and tip pooling. So you can have directly tipped employees who are employees that receive tips from customers without any intermediary, like when you tip your waiter. You can have indirectly tipped employees who are employees that without receiving direct tips can receive shared tips or contributions from a tip pool. Tip sharing is where a directly tipped employee gives a portion of their tips to another service employee or a food service worker who participated in providing service to customers, which keeps the balance. And tip pooling is where tips earnings from directly tipped employees are put into a common pool, then redistributed among directly and indirectly tipped employees. So both are allowed under New York law, and a restaurant does not need to get an employee's consent to implement a lawful tip pool scheme. What is very important, and we caution you, is that only people that are eligible to receive tips, meaning people who engage in service to customers, are included in that tip pool, and that none of them are managerial staff. So people who are typically in tip pools are wait staff, counter personnel, people who serve food or beverage to customers, bus people, bartenders, service bartenders, barbacks, food runners, captains, hosts, and dual tip, non-tipped people. The people that we sometimes see in lawsuits that appear in tip pools that could invalidate the tip pool include managers, sometimes captains with those kind of borderline roles where it could be argued that they're really managers, people that are setting schedules that can make decisions about other employees' work, who could recommend someone be fired or promoted. Those people should not be in the tip pool. It's not just about the title that they have, but about what their duties are. So make sure that no one that can be borderline a manager is in the tip pool. And then the other thing we caution about are people that are really not engaging in service. So these are porters, stockers, expediters, polishers. I I've had a case where someone was making coffee, and we got into a whole argument about whether he was really coming out of like the little coffee nook and like giving the coffee to the customers, or if he was just making the coffees and servers were picking up the coffee and providing it to the customers. You really get into these arguments in litigation about the duties of the people that are in the tip pool. So it's very, very important to make sure it's just people who are non-managerial and actually dealing with service to the customers.
And the service that they provide to the customers has to be has to be a principal part of their duties. So, expediters are a common position. So a lot of times there is plenty of cases out there where there's no one in the tip pool with the title of an expediter. There are runners who are really expediting. But the question is, if a runner's just standing at the pass bar for most of the shift and not actually serving the food, touching tables, as a principal part of the runner's duties, for example, notwithstanding whatever the title that you have for that position, it can create a problem. So really, this is all about duties, not titles. And that's something that, everyone should be cognizant of. Same thing if you have servers, but, or some sort of service staff who have additional responsibilities, like Catalina was mentioning. Like, are there individuals who another employee might think is inappropriately included in the tip pool because they're a manager or a supervisor? Like, are they scheduling? Are they cutting employees early from the end of their shift such that they're directly impacting potentially an employee's take-home pay? Things like that are red flags and should be looked at carefully to ensure that you don't have someone improper in the tip pool. Because although the law is not necessarily settled, there's a number of courts out there that have said, and plaintiffs' lawyers argue all the time, that if you have someone in the tip pool who should not have been in the tip pool, that it poisons the pool for everyone else. So not only do you have to redistribute the tips that went to the ineligible person, but plaintiffs' lawyers will also argue that it invalidates your ability to take a tip credit, and that you should have therefore been paying everybody the full minimum wage. So it is potentially a very significant penalty.
Okay, lots of questions about this in the Q&A box, but there's a lot of nuance and individuality to the questions based on very specific tasks that people are asking about. So I guess one question that sort of is overarching. I'm someone that works 5 hours as a busser and 3 hours as a polisher, for example. My understanding, this person who's asking the questions, understanding was that they could not receive tips because they failed the 80-20 rule. Is that?
So that's a nuanced question, and I will tell you that there are different philosophies, even on our side of the table, from different advisors in this area as to the way the hospitality wage order reads, right? So the hospitality wage order is the Bible, for lack of a better term, with respect to the regulations governing the wage and hour space in this industry. To me, I don't believe that's not the way that I read the hospitality wage order, but I know that there are others who read it differently. So, this is really a question that people should be directing to their advisors. Generally speaking, I'm typically comfortable with the idea that if someone fails 80-20, that they're still eligible to receive tips, so long as they're only being tipped for the portion of their work that is spent on the floor and not in the non-tipped position. So if there's a point system in a pool, for example, and it's done on an hourly basis and you're getting a point for each hour, if someone's only 5 hours on the floor, 3 hours working as a polisher, the person shouldn't be getting 8 points, for example, in that pool. It should be reflected. But I will tell you that there are other experts out there who think that if you fail 80-20, you shouldn't be in the pool at all. So that is a bit of a open issue.
Controversy.
Yes.
So I guess I just want to ask this one also, but I think this is along the same lines. What if someone works as a manager for lunch and as a waiter for dinner? Can they share in the tip pool?
Yeah, so
Same idea.
So this one's a little bit different. So this one always makes me personally uncomfortable because here's the problem. And look, this happens, and as all of you know out there who are operating restaurants, it's often very difficult to hire managers, right? Because it's hard to pay them what you need to pay them to get them to forego tips. And so you end up in situations where you need coverage at the restaurant because you can't have one manager just working, being there every hour of every single day of every single week. And so, you have to come up with solutions. So I understand that this is, there's a practicality here. What I will say is that I think it is, generally speaking, if it can at all be avoided, it is a bad idea to have someone as a quote unquote part-time manager, part-time in the pool. Whether it's technically unlawful or not, we can argue about, but what you're trying to avoid is employees believing that there's someone inappropriately included in the tip pool, because that's how all of your problems start. So if an employee thinks that there's a manager in the tip pool because the employee recognizes John or Jane from Wednesday afternoon telling them when they can go home and when they're going to work, but then John or Jane is in the tip pool on Thursday, the employee is going to say, well, you can't be a manager on Wednesdays and not a manager on Thursdays. You're either a manager or you're not. And that can often contribute to an employee going and, seeking an external solution. So I think it is very difficult to be able to wear a manager's hat only part of the time, because in the eyes of the employees, if you're a manager, you're a manager, and you're, sort of bestowed with that authority throughout your employment. So we really advise, we really try to push restaurants to whatever degree possible to find other solutions. But at the very, very bare minimum, if someone has any sort of managerial authority on a shift, they should not, they absolutely should not be anywhere close to the tip pool or receiving tips.
Agreed.
Okay, just very quickly on events, to the extent that this has been another area of litigation that's been very prevalent over the last, decade. If you are a venue, a restaurant that either has event space or rents out your restaurant or portions of your restaurant for special events, and you enter into contracts with your customers who are renting out the space, a lot of these contracts, the language in these contracts and on all of the related event paperwork, whether they be BEOs or invoices or whatever the documents that you use are, it is important that there are no charges in connection with those events or in those contracts that could be confused by a customer as a gratuity, unless it is actually a gratuity. So, for example, there have been like the term service charge is a dirty word in this space. You don't want to be using the term service charge because it is automatically going to be construed as a gratuity under New York law. And if you don't intend it to be a gratuity, you have a problem. So the hospitality wage order has very specific regulations that say if you are going to charge if there's going to be an ancillary charge in connection with your event or your contract in connection with an event, that there has to be a very explicit disclaimer that makes clear that that charge is not a gratuity and is not distributed in its entirety to the service staff who work the event, but is rather used to offset the administrative costs of the event. And so that fee is supposed to be referred to as an administrative charge or an administrative fee. It's taxable, and it is not, and you have to be explicit in at least 12-point font. I'm not making the 12-point font up, as silly as it seems. And not only does it have to be at least 12-point font, it can't be smaller than the surrounding text. It has to be very clear to the customer on all of the event documents that charge that you have included is not a gratuity. Otherwise, it will be deemed as a gratuity, and you will have to pay that amount out if there is an adverse ruling to everyone who worked the event. And when we're talking about these amounts, some of these amounts can be significant because some of these parties can be quite expensive. So it's been a very hot area of litigation over the past decade or so. And it's something that we're continuing to see on a regular basis. So something that everyone should be doing is checking their event paperwork, working with their employment counsel, making sure that you are buttoned up in terms of language.
And I would just add that this is beneficial to you. You don't want your customers to be confused about where the money's going and not tipping. So if they are confused, they think that they're paying a gratuity and that it's going to the wait staff, then they're not going to tip above, and your employees probably won't make the threshold, or won't get as many tips and won't be as happy. So it's an easy way to keep your staff happy, to make sure that everyone's getting paid correctly and that there's no confusion about whether they have gotten their tip or not. So the next area, this is highly important. I've been seeing a lot of rounding cases lately coming onto my docket. So it's important to keep accurate time records. It's the law. The Fair Labor Standards Act requires it, and the New York labor law requires it. Anyone that's being paid on an hourly rate, you need to be keeping accurate records. Technically, in New York, you are allowed to round you're allowed to round, but it has to be a neutral policy that sometimes benefits the business, sometimes benefits the employee. However, I think Adam and we've been burned on some cases on this. It's really, really discouraged, I would say, because then you're gonna have to prove that it's neutral, and if it's not neutral, then you could owe significant amount of money to your employees if they can show that it was more beneficial to the business. Auto deductions for breaks are also something that we're seeing a lot of. So if you are not paying employees for lunch, you should require them to punch out and punch back in. And if they fail to do so, you should not automatically be changing that. You should pay them, you should penalize them, you should like with some sort of discipline, like a write-up, so that they are aware that they need to be clocking in and out, but you should not be auto deducting without their consent, because we see a lot of lawsuits and people claiming that they have to work through lunch and they weren't paid for that amount. Sorry.
Sorry, before you go on to the last piece, Kat, just the paradigm really is that you want to be able, and this is achievable. This is much easier now than it was 20 years ago, because a lot of restaurants out there, most of them have some sort of electronic timekeeping system, whether it's through their POS system or otherwise, it's done electronically. So generally speaking, the way that, like, from Catalina and my perspective, when we get a new litigation and there's one of these claims, what we like to be able to do is say, okay, give us the punch records, the time records for this employee for the last 6 years. Catalina mentioned it before. The limitations period in New York for any of these wage claims is 6 years. It's the longest in the country. So what we like to be able to do is say, give us your time records for this employee and give us the pay records. And we like to be able to say, okay, if we go from punch to punch and calculate the time, we want that to match to the minute what they are actually paid for. That is the goal. That puts you in a significantly better position to defend one of these claims. If there are automatic deductions such that we have to say, okay, it doesn't match up because we were deducting automatically an hour for a break, or there was rounding, and we have to make sure that the rounded punches are both going up to the nearest quarter hour, if that's what the rounding scheme is, or down to the nearest quarter, it becomes significantly more complicated, and there's significantly more room for a mistake or for an argument on the other side that there's some sort of liability or impermissible scheme. So that's really what we strongly, strongly believe everyone should be striving to do, is to have the time records match to the minute the pay records.
And I would add that I guess my dirty little secret is that I used to be a plaintiff side lawyer, and I sued a lot of restaurants on behalf of employees. And one of the things that made my job really easy is that if there are no time records, or there's any sort of inkling that the time records are not accurate, the law assumes that what the employee is saying is accurate. And again, some of these laws are incredibly unfair. They weigh towards the employee, and it's hard to defend. So there's so many resources available through your payroll company, through software that you can acquire to have records up to the second, and you should be paying the employees for any time that they're clocked in. So you can defend against these incredibly unfair laws that tend to not favor the employer as much.
Okay, just very briefly, because we want to save a few minutes at least for questions at the end. I see that there's a handful of them. So just everyone should just be aware that both New York State and New York City in the last year or two have implemented a pay transparency law that requires, and we're not going to go into details, but it generally requires that whenever you make a job posting, whether internally or externally, that in that job posting, you have to include a good faith salary range, a good faith estimate of the salary range for the position. And there's no exceptions to that. And we are now starting to see enforcement of these laws. They were so new that it's only been recently that we've seen some enforcement, but we are seeing enforcement, and especially in New York City, but also New York State, there are potentially severe monetary penalties for violations. So just something that everyone should be cognizant of as you are advertising for positions.
And then independent contractors, there's a new federal proposed rule for standard to evaluate whether someone is an independent contractor or an employee. There's been back and forth over the years as to how to determine if someone is truly an independent contractor, but the question is still basically how much control do you have over that independent contractor? Are you telling them when they have to do the work, how they have to do the work, or are you telling them, or are you letting them do that themselves? And if they are misclassified there, and they are really an employee, you may be on the hook for the minimum wage if they weren't being paid the minimum wage, overtime for any hours that they worked over 40. You may be on the hook for not keeping records of their time. So it's really important that anyone that you're engaging on an independent contractor basis is truly an independent contractor and not someone that's an employee.
And the other bucket of risk that I'll just add briefly, and this is sometimes where it comes from, is that if you have an independent contractor who either doesn't understand that they're classified as an independent contractor or believes that they're misclassified, and the engagement ends, sometimes they file for unemployment. And you can test unemployment because you say that they're not an employee, and the Department of Labor starts investigating. And sometimes that investigation is not just related to this one individual employee. It can be expanded to any other contractors you might have. And if you are deemed by the Department of Labor to have misclassified these individuals, you will also owe the government money because you have not been withholding taxes on the payments that you've made to this employee. And the government is going to come knocking on your door for penalties assessed as a result of those unpaid taxes. All right, so just the last slide, very brief. I think we've talked about a lot of these, but and we've emphasized it as we've gone, but just everyone should know that even a small violation, unfortunately, can lead to several categories of damages, including penalties like statutory damages. Then there's the wages that the employee alleges that they're owed, and that if there are wages that are owed, if under the law, there's essentially an automatic implementation of a penalty of liquidated damages in 100% of the amount of the unpaid wages. So if you owe, or if you are found to owe an employee $100, that really becomes $200. in addition to having to pay the other side's attorney's fees if they are successful. So unfortunately, even small violations of small monetary values can add up relatively quickly. And then when you add in the other side's attorney's fees, it often becomes a case that from an economic perspective is not feasible to fight. So that's why we work with clients as much as we can on the preventative side of things before there's an issue, because really once there's a claim, it creates a very difficult economic catch-22 for employers, even when the liability is theoretically limited.
And plaintiffs' attorneys tend to bring these cases not just on behalf of individuals, but on behalf of a class. So what, is pretty bad with one employee is even worse when it's your whole front of the house staff or your whole back of the house staff.
I think that's it. I know that there's some questions, Sarah. I know Catalina and I can stay an extra couple of minutes if need be, just so we can get to some of these. You can let us know.
Okay. There's quite a few questions around meals and meal periods and breaks. So I'm wondering if you want to do those now, or if we want to set a time to come back and you guys can do a webinar on like a quick and dirty on meal periods, however you want to handle it.
So we can certainly do that. I mean, there's a lot in that topic. So I think we probably better serve doing that, and you can
Okay.
hold Catalina and I to that, and we will come back soon, and we can spend maybe half an hour just on that topic.
Yeah, I think that would be a good idea. And if you do need information right now, we did a webinar about 2 years ago on meal periods, and it's in our webinar archive on NYSRA.org. So that's an option. So I'm going to set the meal period questions aside, and we will fast forward that to a later date. Okay, if we're going back, and the question is on the form you provide your employees with the wage rate notice. The minimum wage for servers entered on the form, is it $10.65 or $16? And I know you addressed this, Adam, but I just wanted to get a repeat.
Yeah, no, it's a good thing to go over again, because we see this mistake more often than not. Technically what it should be put in on the form is the full minimum wage if you're taking a tip credit. So it's the 15 or 16 depending upon where you are, and then you indicate in the allowance box, you check the tips box, and you put in the amount of the credit that you are taking, because really all of these front of house employees are minimum wage employees. It's just that because you are meeting certain conditions, you are eligible to take a credit against the minimum wage. That's what you are doing.
And same goes for the overtime rate. It should be the 24 in the bottom overtime part, not the tipped OT.
Time and a half, the minimum,
Yeah.
full minimum wage, not the tip credit minimum, the overtime rate.
Okay. Let's see. Sorry. Admin fee. Can you use a portion of the admin fee as gratuity?
So you're not, so, well, that's a loaded question also. There are all sorts of ways that you can set up the your event contracts. You can have a split admin fee gratuity. So that is permissible. The regulations do allow that. You can use the admin fee to pay your employees a higher rate, like party pay, for example. The idea is that if you set it up correctly, the administrative fee is your money. It is revenue to the restaurant. But in order to have it be revenue for the restaurant and to have it be set up in that way, you have to make sure you include all of the necessary language to make sure there's no customer confusion. And if you are splitting the admin fee, if you have a partial admin fee, partial gratuity, again, you would still need the disclaimer for the portion of the fee that is not a gratuity, and you would need to make sure that that setup is very clear to customers, because the standard under the law is one of customer confusion. And in order to litigate one of these cases and win, that means that your customers would be relevant witnesses, which no one wants to be in a situation where you're, bothering your customers to come in and testify as to their understanding of what the setup in your contract was.
Okay, and then that leads into did you say during the presentation that any service charges that aren't labeled as gratuity are taxable?
So if you have, so gratuities are not taxable, but any other charge aside from a gratuity is typically going to be taxable because it's going to be revenue for the business, whether you call that a room fee rental, administrative charge, a processing fee, whatever the other charge is, it's typically going to be a taxable charge, yes.
Okay. All right. Let's see, hourly rate, I guess advertising your job placements. When placing an ad, how should the hourly rate be listed? Should the cash rate after the tip credit, hourly without tip credit, or average tips included be listed?
Yeah, so those are, so I don't, the job, it's clear that you don't have to include the estimated tips amount in the advertising, in the advertisement. You can say, you know, if the wage rate, and as ridiculous as this is, if you know that if you're advertising for a server position that you're going to be paying the minimum wage, you know, you'd say the estimated range for the rate would be $15 an hour or 16 wherever you are to $16. There is no range because that's what you're paying everybody. You can certainly include, you know, plus tips. That's fine, but there's no requirement to estimate the value of the tips on the advertisement.
And when you were referring to, I guess, sort of at the end of the presentation, you know, Catalina, you were talking about the wrap up of how, you know, you want to keep all these things in lock, largely because you don't want other employees to make claims that open up like a whole Pandora's box for you. So of those claims, can owners be personally liable for these things? And I don't know if that goes to how your business is set up.
You want to answer that, Kat, or you want, like me?
I can take it. So there is individual liability. We see in these wage and hour cases that usually the owner will get named, some managers, and it depends on the degree of control and whether they implemented those policies. So if it's, you know, if it's an owner that never visits the restaurant, maybe they won't be found liable in the end. But if it's someone that's there and operating the restaurant, there can be personal liability for that person. And certainly we see both named, and then we have to defend that and try to get them dismissed if it's someone that's not, you know, actually that involved.
And in addition to that, I'll just say that so Catalina is right that if you're an employer, you can be an individual and be deemed an employer under both New York and federal law, in which case there would be individual liability if you are named in the complaint, and that's a question of control. But also keep in mind that New York State, under the business corporation law, has a section that provides individual liability for wages of employees for the top 10 highest shareholders of closely held corporations. So there are multiple ways in which there could be liability for an owner in connection with one of these claims.
Hey, that's good information. Back to the pay rate acknowledgement form. If the restaurant doesn't take the tip credit and pays, well, this says if our restaurant does not do the tip credit and pays the front of the house $12 an hour, should we also write in plus tip on the pay rate acknowledgement form?
So there's no requirement under the law that you have to take the full amount of the tip credit. So if you're paying your wait staff $12 an hour, you're still taking a tip credit. You're just taking a lesser tip credit. So your forms would be a little bit different. Your forms would say if you are in a place where the minimum wage is $15 an hour, your form would say $15 an hour in the rate box in box 1. Or box 2, whatever the rate information is. And then in the allowance box, it would say you would check tips and you'd put $3 in that box because you are taking a $3 credit against the minimum wage.
Okay. Let's finish on one here. There are more questions, but we're going to have to cut off here at some point. So last question for now. If there is tip pooling, everyone involved in that tip pool needs to be making the same hourly wage? That's the question.
Catalina?
Sorry, someone just walked
No,
in. I didn't hear
got
the question.
No,
That's okay.
no, I heard it. No, the answer is no. You can have people in the tip pool who are making different rates of pay. That's fine. You want to, there should be generally, so long as the people in the tip pool are non-managerial employees who are working in roles in which touching tables and engaging in customer service is principal and customary to their role. So long as those qualifications are met, doesn't matter if you're paying like a more senior server $20 an hour, for example, and they're getting tips along with people paid at the tip credit rate.
Okay. All right, we'll end on that one. Again, we'll come back and talk about meal periods at a later date, but not too far from now, hopefully. There were some other questions on admin fee. We did just do a webinar at the beginning of the month on what you can charge your employees for.
You can go back and review, I'm sorry, not your employees, what you can charge your customers for, what they can be billed for. So
I was going to say that the webinar of what you can charge your employees for would be a very short one. It would be basically zero.
I'm sorry. Yes, what you can charge your customers for, what they can be billed for. We did that earlier this month, so you can review that in our webinar archive if you have questions on those subject areas. And as always, Catalina and Adam, thank you so much for your time. Very comprehensive. We appreciate it. And if anyone wants to get in touch with Adam, Catalina, or anyone from Jackson Lewis, you can email us at info@nysra.org, and I would be happy to put you in touch with them. Have a great day, everyone. Thank you so much.
Thank you, everyone.
Thank you.
Take care.
All right, guys. Having a hard time closing it down here. Bye.
Bye.
Thank you.